The empty.
Something we said?
SJC-11786, Angela Sarkisian, The Concept Restaurants, Inc.
May it please the
Wait,
court?
wait.
Thank you.
Okay, Ms. Stern, now you may begin.
Thank you. May it please the court? Karen Stern from Bernstein and Stern in Worcester on behalf of Angela Sarkisian. This is a case which was originally filed in the Worcester District Court, and the defendant filed a motion for summary judgment on the grounds that the traditional approach to premises liability is what should hold, and the court, without an opinion, allowed that motion for summary judgment. We then filed an appeal to the appellate division of the district court, and the appellate division, while affirming the motion for summary judgment on the theory of the traditional approach to premises liability, also had, I believe, an important footnote which indicated that in reviewing these cases and understanding and applying the Sheehan versus Roach Brothers Supermarket case, excuse me, that until this court clarifies that the mode of operation approach in a premises liability case can be applied in a situation other than a self-service operation, that the court must still apply the traditional approach. We then went to the Massachusetts Appeals Court, which again affirmed the decision, excuse me, affirmed the decision, again, of the appellate division, and made a comment in the opinion suggesting that, again, until this court re-examines or clarifies the Sheehan versus Roach Brother case on the issue of whether or not the mode of operation approach can be applied in a situation that is not a self-service establishment where someone was injured.
Yes, but the appeals court seemed to suggest that, quite apart from its own opinion, that a lot of states that had, state courts that had initially jumped on the bandwagon of mode of operation were limiting or restricting, or two legislatures had changed it, but forget that. I mean, but we're limiting the circumstances in which that framework would be used. So I guess that leads to my question, which is, in this situation where you've got a bar and with a dance floor, I mean, basically, you would say what? The answer is you just cannot have liquor on the dance floor? I mean, it's not clear to me whether it doesn't become as a rule that says you've got to absolutely change your entire, you can't operate this way. It's inherently dangerous almost. I mean, that's where it comes out here. Is that what you say?
Well, that's in this particular case, and I think the facts of this case are unique, where the patrons, first of all, paid a cover charge to get into the club. This is a club that's 10,000 square feet, that has 4 bars, that has 2 bars right on the dance floor, one 50 feet long and another 15 feet long in another area. So they have literally 4 bartenders serving drinks on a dance floor. They then give the patrons who pay drinks, and they are allowed to take the drinks onto the dance floor in open containers like this in a plastic cup. Now, you add taking such a drink, open, not a cover on it, onto a dance floor, and you apply the fact that it's an enormous dance floor. This club holds almost 600 patrons. There's a disc jockey playing where the music and the lights, there is a light show going on the dance floor where there are colored lights going on, strobe lights flashing, sometimes laser lights, sometimes even white steam or smoke coming for ambiance with the colored lights. The dancers and the people on the dance floor cannot see the floor. So if you are allowing...
But does that mean you have to have, in such a place, all the drinking in a separate room? Is that what, I mean...
No, but I think that you have to, on the way that this nightclub operated, there are other ways that that are safer for patrons, such as Angela Sarkisian, who had never been to this club before, who didn't know what to expect. There are...
You mean she didn't know that there was going to be drinking in the club and people were going to be on the dance floor? How is that possible?
I don't think that she knew that there were going to be hundreds of patrons on a dance floor drinking and dancing, that she would be unable to see the floor.
Well, she could see that at some point during the evening, though, right? That was what was happening.
Well, you know, she testified at her deposition that after she fell and she felt her pants were soaking wet, she then, I mean, the natural reaction is to look to see what you fell on. And she saw that she fell on all this liquid on the floor, and she looked up and she saw people dancing in the vicinity with the drinks in their hand. That's when she certainly recognized that there were people on the dance floor dancing with these open containers. Remember, again, the facts specific to this location.
But if we adopt that rule, if you're a business, I mean, are there any limitations to this? Or does this just become the slip and fall rule, that mode of operation is how we judge whether it's reasonable or not?
First of all, I do think that this would not be a new rule to this court.
Well, obviously not, given Sheehan. I get that.
Given Sheehan says that it also applies to the mode of operation and not just to self-service. So all you would be doing is clarifying.
Can I ask you, just in connection with that, the amicus brief that favors your position is saying that really this mode of operation analysis is a red herring. Do you adopt the position in the amicus brief, or do you disagree with it?
Well,
because they're saying that it really all goes to the quantum of proof needed to prove the notice of a defective condition, and that here spillage was foreseeable and notice was implicit in the condition, and therefore there was constructive notice, which is a somewhat different analysis. It seems to be more the traditional approach, and saying this whole mode of operation dichotomy seems to be a red herring.
Well, I think the issue in this case is again, not how long the liquid was on the floor and whether or not the owner had actual or constructive notice, but whether in allowing patrons to go onto the dance floor with the open containers, they created the reasonably foreseeable condition that third parties would cause this dangerous condition. And I think that's the limit that I would suggest to the court. If you were to...
But what about establishments that allow people, forget about the dance floor, even when there's no dance floor, there are a lot of establishments that allow patrons to get up and get their drinks at the bar and bring them back to their tables if they drop ice on the floor. This mode of operation would also create liability in those circumstances.
Well, I think if the injury, if it's reasonable if it is reasonably foreseeable in a particular mode of operation that the owner is creating a dangerous condition by third parties, in other words, as you're saying, by giving a drink to somebody who then causes the drink or portions of the drink to fall, then it's reasonably foreseeable that the owner needs to take certain precautions to make sure that patrons don't have this dangerous risk in
Could I
front of
just
them.
take, so assuming we did this and really viewed it as something we've already said, and it applies to these limited circumstances where you've got a bar, no waiters, two bars on the dance floor. That's, as far as I can tell from the record, that's how you get around, you dance that way, you walk around that way. That gets you by, it does get you by notice. It's reasonably foreseeable that somebody else is going to drop these drinks and you're going to slip on them. And then you still have the burden of reasonable measures commensurate with the risk. So that's what you're saying. It's not a fortiori liability. It's that given this, and reasonable measures does take into account, I think, well, who wouldn't know? Or, what is how often should somebody be sending bar backs out or people out to be checking the debris? What is the requirement what is the reasonableness here? Is that what
Yes.
I'm hearing you say? So
Yes, Your Honor.
there is something about notice in there, but that only gets you to the jury. That's just the beginning.
Right, and then the plaintiff still has the burden to prove that the owner was not reasonable or did not take adequate steps to prevent the known risk that this situation would cause. The plaintiff still has that burden.
Would this apply to buffet functions where just Coca-Cola or Pepsi-Cola are served and people get up and get their own food?
It could apply to that. However, how would an owner get around it? An owner, all they have to do is to, understanding that people may drop food products on the floor, they can make policies about how they clean, at what intervals they check to make sure that the flooring is safe for their patrons. They can assign duties to certain employees to make sure at certain intervals that the floor is wiped clean. And this is what is happening after this court entered the Sheehan case. The self-service establishments changed their ways, and they now have written policies, and people who go out into the aisles of supermarkets and the retail stores, and they're assigned to make sure that the flooring is clean, that there's nothing that's fallen, they pick it up, that the shelves don't show as if something's about to fall. And so this court's decision on that issue in 2007 made it so much safer
And the response
for
to that,
customers.
I don't hear you saying that they nonetheless could be then, if they do that, then what is a plaintiff going to show in terms of reasonableness or unreasonableness? They're not going to get by that? As long as they establish, right, if the defendant establishes reasonableness, then the plaintiff doesn't get to the point of recovery. Is that what you're saying?
That's correct. If
Whose burden is it
the burden,
to establish unreasonableness?
Plaintiff.
the plaintiff's burden is to show
Sorry.
unreasonableness. And the defendant, in this case, I can show that the defendant, liquor store, had no policies. They've identified that there were 8 security staff and 3 bus backs who were responsible for quote-unquote safety in the club that night. But there are no written policies, there's no logs. There's no evidence that they went out at any set intervals to take care of this floor. Now, even when we think about the Boston Celtics or any of the professional basketball teams, we know that when play stops or there's a timeout, there are people who run out onto the floor with wiping, with towels and instruments to wipe off any kind of liquid on the floor. And that's because liquid on a floor where there's activity here, such as dance activity, here where you cannot see the actual floor because of the nature of the lighting, dim lighting in the club.
So is there a track record here, by the way? A track record of accidents at this club?
No, that's interesting you say that. The defendant claims that there never was any other person who was injured
That he knew of or could think
or
of.
who fell on liquid on the,
Did you do discovery on that issue?
pardon?
Did you do discovery on that issue?
I asked the general manager of the club at deposition, and what I want to point out, because it's in the record, because I think the liquor store has provided some their claim is misconstrued. The question that I asked of the general manager was, he said that there were no other lawsuits except for Angela Sarkisian's. I asked him, had you ever observed anybody falling on liquid on the dance floor? And he said, not that I can recall. And the third thing was, I said, well, have any of your staff ever come to you to tell you that they saw somebody fall on the dance floor from liquid? And he said, not that I recall at this time. I think that's a little different than saying there is absolutely no evidence that people fell on the dance floor. I suggest this is a recurring risk. In the other jurisdictions of the country, they go by different, there's the traditional approach, some take the burden shifting approach, some use the zone of risk approach, some use the recurrent condition, that's Maine, Arkansas, and Nevada, and then there's the mode of operation approach. And I suggest that in the Sheehan case, it specifically says at page 791 that you can use it either for the self-service operation or the mode of operation of a business. So that if this court were to make a ruling, I suggest that it's just clarifying to the lower courts who are struggling with this issue right now. There are some who are saying, yes, it's only for self-service, and others who are nibbling at it and saying, no, we think that this particular mode of operation was reasonably foreseeable, that people such as Angela Sarkisian would be injured by third parties caused by the mode of operation of that owner. So for these reasons, Your Honors, I think that some clarification to the lower courts and to counsel would be very helpful on this very important matter of premises liability law.
Thank you.
Good morning, Your Honors. Richard Neumeier for Concept. I would just like to point out a couple of additional facts. This claimant arrives at 9:45 p.m., and she has 2 beers over the course of almost 4 hours. The accident's at 1:30. She doesn't observe any spills or any other accidents until this accident
Wait a minute, excuse me,
happens.
she doesn't,
Excuse me?
well, she didn't see as she was walking. The question really was, did you see any liquid as you were going up the steps?
Right.
I didn't notice any at that point.
Right, but there's no evidence that she noticed any liquid spilled anywhere else, anywhere during a 4-hour period of time. I suggest this court should decline the request to extend the mode of operations beyond self-service establishments for 2 reasons. The plaintiff has not articulated any principal basis for avoiding what would amount to strict liability. And the plaintiff cited no case from any jurisdiction in the United States in which this has been done. And we have slips and falls all over the place.
Let me just take you up on that, though.
Sure.
If you went this way and you said, you just taking the language from Sheehan, that the owner could be liable if it could reasonably foresee a dangerous condition exists and fail to take adequate steps to forestall resulting injuries. It still would be, the owner could indicate that it had people, wandering through the dance floor all the time to make sure that there weren't you'd still have to prove that in the circumstances what the owner did was negligent. It isn't strict liability. Oops, I fell, there's liquid on the floor, that's it.
As a practical matter, on this record, it is strict liability. Why do I say that? There are 8 security staff who are wandering around. There are 3 bar back bus staff. There's the club manager, and there's half a general manager. I say half a general manager because the general manager is walking back between.
Well, but you didn't get beyond the summary judgment. So maybe you would put all that in, and the jury would say, yeah, that's reasonable.
Well, that's the real question. I say, as a matter of law, whether that's sufficient or not is not within the common knowledge of the average juror. If that is insufficient, the plaintiff really needs an expert to say that's insufficient. And I would invite Your Honor's attention.
What's insufficient?
If
the expert to say what's insufficient, I don't get that.
What you need is a safety expert. There was a safety expert in the Idaho case cited by the plaintiffs in their application for direct appellate review. McDonald's versus Safeway. That was a slip and fall on an ice cream. There was an ice cream demo at Safeway's, and the person slipped and fell, and there was an actual trial. The slipped and fell on melted ice cream. And the Safeway, of course, put on their people that said, here's what we do for safety, and so on and so forth. And the plaintiff had an expert that said, that's defective because. Now, you do need to have an expert that qualifies under the Lanigan rule, but that's not a difficult
But we'd be in a
rule.
different posture, though, if the court said you failed here because you failed to have an expert to demonstrate that the nightclub was negligent.
But under existing law, you can do that. Under existing law, you can have an expert. I mean, how is a juror going to say that having 11 people is not enough for this establishment? It's just not possible.
But that's a different issue. I mean, the first issue is whether or not they had notice, and the mode of operation matters in terms of whether or not the risk is so foreseeable that we expect the owners to take reasonable steps to protect against the foreseeable risk. And then the second issue is what they did reasonable under the circumstances. And so I understand that you may ultimately, if you get to trial, be able to say, we told the bartenders only fill the cup up 3/4, don't fill it up to the top because of that risk, and we had our people go around periodically looking for any wet spots, and they had a towel and they would clean it up, and the jury could find that you acted reasonably. But why does that mean you don't?
That's not strict liability.
Let me try to answer your question. What happened here happens whenever a patron orders a beer at a nightclub, a bar, a wedding, TD Garden, Fenway Park, Gillette Stadium. We all know that occasionally someone will spill it, and occasionally someone will slip on it. Is that enough to get to the jury?
Well,
That's
but the
foreseeable
difference
that's
is
gonna
that,
happen.
except on really good nights, not everybody at Fenway is dancing with the beer that they've just purchased.
And the bar isn't right next to their seat.
Well, what is the limiting principle here when the plaintiff here says you shouldn't go on the dance floor? Does that mean at TD Garden I can buy a beer and take it to my seat, but I can't go to a common area
But I mean, she may be wrong that is what she would need to show to prove liability. It may be that you can act entirely reasonably and let people carry their glasses on the dance floor, but you need to take steps to prevent against the risk that people will spill. And that may mean you have people with towels watching for it, and it may mean you tell your bartenders, get bigger cups and only fill them 2/3.
I guess on this record, what does that mean? When this court writes it up, what is it going to mean for everybody else?
Well, but we're not,
and-
but
and-
I mean, but the issue is really, I mean, as far as I can tell, and maybe I'm wrong, Lord knows I've been before, the question here is the foreseeable risk of a spill here essentially as great as the foreseeable risk of a fallen grape in a grocery store?
But the reason why there's a difference in the requirement the reason why self-service is different, Your Honor, is that employees do take care. If you let customers take the grapes, sometimes they're in a hurry. They owe no duty to the store to make sure that the premises
Neither do
are
the
kept well.
dancers.
Excuse me?
Neither do the dancers when they're going onto the floor with a drink.
There's a sense in which this resembles self-service, I
Yes,
think,
right.
is what we're getting at.
Every other court that has looked at this, every other appellate court that has looked at this has concluded that this amounts to strict liability if you permit a customer to do something and then the owner is responsible.
I didn't really find a case quite like this, where the circumstances, the factual circumstances, the mode of operation were so close to self-service. And I don't mean that there's a bar and you buy a drink. I mean that there is a bar that is on the dance floor, 2 bars on a dance floor. As far as I can tell from the record, the only way that you can leave with your cup full of liquid is to cross a dance floor filled with dancing people. And then beyond that, people are allowed to dance with these cups in their hands.
Right,
So
right.
that is quite different from any other circumstance. So it's a unique circumstance, perhaps, unique to places that allow dancing while holding beer, and the only place you cross the dance floor is from the bar is
I really
through
don't.
this throng.
I really don't think it's unique in the sense that all of us have been to weddings where there was dancing and there was drinking, and some people took their drink onto the dance floor. I mean, that's really the closest case that's analyzed this very well recently is Konetsky versus Post-Royd Entertainment. And I would ask you to take a look at.
Is that the Connecticut
That's
case?
the Connecticut case.
With the beer tubs?
With the beer tubs. And
Counsel, let me ask you, why is it that the plaintiff would need to have an expert in this case? I don't understand why it's not common sense.
The plaintiff says the defendant was understaffed. The plaintiff says in the brief there were only 11 people on the floor. How is the jury going to figure out that there should have been 17? Well, actually, the plaintiff doesn't say how many additional there should be.
But is that the basis of her claim, that there weren't enough
Well,
people?
that's one of the things she says. She says a bunch of other things that she says other establishments don't permit drinks on the dance floor.
She says there aren't any written policies or responsibilities assigned to any of these people so that you know that they're going to follow written policies about checking the floor. That's what she says, and that was the testimony in this case.
Well, I think it would be really hazardous to say that
The deposition testimony, excuse me.
that it's negligent not to have a written policy when the
Any policy.
Well, the testimony is that the 8 bouncers are to look for spills on the floor, among other things, and so is the bartender, so is the club manager. Now, that's the testimony. That's one of the things they're supposed to do. And if they see something, they're supposed to clean it up.
Right, but just if they see something, there's no regular rotation of checking, right? Or did I miss
Well,
that?
that's true, and the question is there something negligent about that in the absence of any evidence of a spill in a 4-hour period?
But is that the issue that's before us? I thought it was the foreseeability issue.
Well, as I understand the plaintiff's plea to this court, it's to push the mode of operation analysis beyond self-service establishments. I think that's the claim.
Right.
And if that's the claim, then you might want to take a look at how this issue has been dealt with in the other 49 states. And that claim has been rejected everywhere by all the appellate courts. Where is the limiting principle here? We have thousands of people go to TD Garden or Fenway Park or Gillette Stadium. We also know that there are people around that are looking for things that are going wrong. Are there enough people? If there's a slip and fall at Gillette Stadium, can the plaintiff get to the jury just by saying, wait a minute, I say there weren't enough people. You should have had more people.
Whatever happened to the case that, do you know, Mr. Newmeyer, what happened to the case, Mill, that is cited someplace by the decision by Judge Cornetta in the Superior Court?
The
It has
theater
to do with
case.
Ice in the Aisle of a dark movie theater extending Sheehan. Has that been appealed?
I don't know the status of that. I don't think it has been appealed, Your Honor, and I think that was simply incorrectly decided. The person arrives late at the movie, wants to see the movie. The theater's dark.
And
What are you
has a
supposed to do?
self-service drink, presumably by somebody else that ice slipped out of, and
Sometimes there are just accidents. What's the theater supposed to do? Say, you're not going to see the theater? Turn the movie off? Turn the lights on?
But but look at it from the other perspective. Let's say that, I mean, is it really a good principle of tort law? If you had a bar, you have no bar backs, you have no security. You've got the dance floor, as huge as it is, you've got these two bars, and people can drink and bring it onto the floor. And the traditional rule of liability is, well, if you can't show when the drink got there, all right, you have one person who's wandering around, but if you can't show when the drink got there, or indeed if you even fell on a drink that was there, too bad. But that's the operation? There should be no liability?
The traditional approach has been fault. And that tradition is worth keeping as opposed to strict liability. When you have 11, certainly if there was no one looking for spilled drinks on the floor, I could see a claim being made that's inadequate.
Yes, but the traditional rule would say tough luck, right? Because the plaintiff can't prove when that drink got there.
I guess I can't cite to you a case on point with respect to that, because as a practical matter, you don't operate a function like this without having anybody. So you don't have that kind of case in the books because it just doesn't exist. The problem with what's happening here is Fenway Park has hundreds of people running around doing stuff. People buy drinks, they buy food. Some of it's alcoholic, some of it's not. Sometimes they drop it. They're careless, they're excited and so forth, they're inattentive, and somebody slips and falls. Now, are we going to say that a plaintiff can get to the jury just by saying your staff was inadequate? It was foreseeable there was going to be a slip and fall. It certainly was foreseeable there would be a slip and fall. We know there's going to be a slip and fall at Fenway Park several times a year. I don't know how many times, but it's just inevitable that somebody's going to buy a drink or a hot dog and drop it.
Let me ask you this. Okay. If you will agree with my proposition that there are circumstances where the traditional rule just seems inherently unfair because you're never going to be able to prove that, and your proposition that strict liability or total liability for all these different scenarios that you've just posited is unfair on the other side, what rule would you adopt?
Well, I think we should stick with the existing rule. Do you really want to write an opinion today that says you can't take a beer at Gillette Stadium and walk around with it after the Pats have won the Super Bowl? I mean, the timing on this would be terrible.
Luckily, I don't have to do that because that isn't this case. But
well,
And because,
but when you do write it
the
up,
Pats would ever win the Super Bowl at Gillette Stadium. So.
but that's true. But when you do write it up, you have to think about the implications, and I'm sure you will think about the implications of what you're saying. And slips and falls are going to occur whenever you sell alcohol or food and people take it away. And what is the implications? I assume my time is up, and I should stop unless there's another question.
Okay, thank you.
Thank you, counsel.